Hi, everyone. We're just going to give people a few more minutes to enter, and then we'll get started. Okay, we will go ahead and get started. Good afternoon, everyone, and welcome to today's webinar or educational update. I am Monica McHale Small, and I am the Director of Education for the Learning Disabilities Association of America. LDA has been advocating, supporting, and educating on behalf of individuals with learning disabilities for over 60 years. We're an organization that was founded by parents in collaboration with professionals and researchers, and we have been on the forefront of pushing for and establishing rights for students with learning and other disabilities from the beginning. Today, I'm very happy to welcome our speaker, Heidi Goldsmith. Heidi Goldsmith is a special education attorney working on behalf of parents for over 20 years. She is on our professional advisory board at LDA. Some of you may have enjoyed Heidi's webinar that she did. I think it was in April. I encourage you to find out more about Heidi by going to LDA's website. And while you're there, if you're not already a member, I would encourage you to take a moment to become a member. Membership at LDA is very, very inexpensive right now. It's only $55 a year. And there is a wealth of resources that we have available to everyone, but then we also have a special members only section that has access to many webinars and other resources. So I encourage you to take a look at that. We're going to begin the webinar now. I'll hand it over to Heidi, but I just would ask that we will have a time for questions, we hope. If you can use the Q&A function for questions. And then if you have any kinds of technical difficulties, please use the chat for that. So at this time, I will let Heidi take it away.
Okay, great. And Monica, I'm happy to, if there's questions that come up, you can interrupt and ask them as they go along, because sometimes I forget what I was talking about in relation to the question. So I'm happy to do that as we go along. Okay, so today's focus is going to focus on about 5 different areas. One, key legal developments, and we had one just arrive yesterday with some, great news for kids with disabilities. Some current shifts in Section 504 and ADA regulations, the executive branch, kind of different impacts and litigation going on around there, going into litigation to watch, and then implications kind of where we're at with students and advocates. Okay. Okay, so this is a case that isn't directly on point to the IDEA, but it is very important Supreme Court decision that came down last year that is having direct and significant impacts on IDEA sections, more so Section 504, and that's the Loper-Bright case. And I'm going to try to take an incredibly technical legal concept and distill it down to what it fundamentally means. But since the 1980s, when different agencies like Department of Transportation, Department of Education put out these regulations that we all lived by, and we know what the Title IX regulations came out. We had new 504 regulations come out, and we went through the IDEA reauthorization in 2004. We got regulations out from the different departments within the federal government. The way courts had to utilize those regulations was as if those regulations were speaking for Congress, meaning that that is what congressional intent is. That's what Congress meant when they wrote that section. And I'll give you an IDEA example. One of the things that is in the IDEA, if you actually read the actual law of 504 and IDEA, it's very short. There's not a lot of filling in the gaps. Where those always came was the publication of those regulations in the Federal Register, because that's what really told us what that meant. So, an example, in the IDEA, the law passed by Congress, it says the district shall periodically, reevaluate students with disabilities. How that process was done in terms of the importance of utilizing different tests and standards, the time frames, all that came through the Federal Register. And again, when courts would review whether or not districts were doing things correctly, they would look to those regulations, say, well, the regulation says, that's the components of what an appropriate evaluation is. This evaluation doesn't meet the standard, or this is the time frame that needs to happen. And so it was a case called Chevron. So we lived kind of under that, whoever that government agency regulations were, those were kind of the force and effect of law. Well, then came along Loper v. Bright and said, nope, all those regulations do not have that impact that you think they do. They do not speak for Congress. And in fact, courts can look back at different things or decide that that's in fact not what Congress intended. So now we are in a new dynamic where we are looking at all the regulations that we receive, not through the lens of if we can prove that that is what they did or did not do. It's more now going back to whether or not that was even the intent of what the IDEA, which was, reauthorized in 2004, 21 years ago, if that was what it meant back then. So there is going to be, and I think the anticipation was there was going to be a lot of litigation about whether or not the regulations were an overreach, but we're now kind of seeing a lot more litigation just surrounding kind of the impacts regarding the DOE. So a lot of the education law centers and those things are focusing on more the bigger, more fundamental things. But as that starts to stabilize, what we have for regulations that we have lived and abided by as cardinal law in the IDEA for the regulations, there's going to be litigation that may work itself up to the Supreme Court, or even if it doesn't, work its way through different circuits, and that interpretation of what that law really means could change. So that is something that I think we all need to be mindful of. Not all laws require regulations. We are lucky that the IDEA is required to issue regulations under 20 USC 1406, because theoretically, the laws that do not require regulations, it would just be the law, and then it would be up to each state and judicial circuit to kind of interpret what those regulations are. So this is kind of a start of what I think is going to be a much larger, longer impact long term in IDEA and Section 504 cases, because again, as we sit here right now, those regulations no longer have the force and effect that they once had. Okay. And I am not a great PowerPoint person, so if I screw this up, I apologize. Let me see if I can get to the next slide. I just got to the next slide. How do I get to the next slide?
You should be able to just hit the arrow keys on your
I
laptop.
am hitting the arrow key and it doesn't. Oh, there we go. Okay. Again, listen, I have as I say, I have a legal partner and we kind of separate duties, and she takes the tech and I don't. But all right. Now, I was very fascinated by this case because I actually grew up in Minnesota. So to see a Supreme Court case, not only in terms of education law, but also in terms of the impact in terms of coming out of Minnesota, I was always very fascinated by this case from its kind of inception. But AGT versus Osseo. Now, again, I know a lot of people say Osseo because in Minnesota, you're looking at that from an O standpoint, but we're really close to Canada, and we like to say our A's and O's a little bit differently, so it's Osseo. But the main issue about this court case was whether or not under 504, which is the only law that really allows for damages for kids with disabilities at this point in time in the ADA, but what level of standard do districts have to prove, or not districts, parents had to prove to be able to seek the damages. And, there are different legal standards. Like there is preponderance of the law, there's beyond a reasonable doubt, there's, deliberate indifference, there's proof of bad faith or gross misjudgment. There was a split, and that's really what the Supreme Court's role is when there is a split on a federal law about what the different standards are, to make a decision as to, this is a federal law, what is the legal standard, so that every person who's receiving benefits under that law are getting the equal treatment, per the Constitution requirement under that law. And so, for example, in Pennsylvania, in the Third Circuit where I practice, we were under a deliberate indifference standard. And that's where you knew of something, but you were deliberately indifferent to it. That is a lower standard of proof than proving bad faith or gross misjudgment. This case kind of evolved out of the school district trying to establish that you must prove this bad faith or gross misjudgment. This almost one of the highest legal standards in terms of, not the highest, but much higher legal standard than deliberate indifference. And they were utilizing a lot more, and there have been a lot more challenges to 504 and ADA to challenge discriminatory practices in education. It wasn't a specific education case, but it did impact 504. It came up probably about 2 years ago, where we lost the ability to kind of pursue emotional damages. Now, whether or not there are still the availability of emotional damages attendant to physical damage, that's still yet to be seen. That's not worked its way through the court system. But the court ruling yesterday came out and said, no, the standard cannot be bad faith or gross misjudgment, because that is a higher legal standard than we infuse on other similarly situated laws. And so, in fact, the deliberate indifference standard, which again is not a low standard, but is lower than bad faith or gross misjudgment, came out. And the one nice thing, and again, listen, people can always claim to read the tea leaves of Supreme Courts. I caution, anybody from doing that, because, you're just reading tea leaves for a great thing, for great mass amount of time. But the fact that it was a universal, every judge ruled the same way, I think is at least a positive sign that the Supreme Court isn't looking to really attack, in terms of for kids with disabilities, at least in terms of, heightening standards, because there is always a possibility that the Supreme Court could say, well, listen, these are school districts charged with, they have protections under 11th Amendment immunity. They're doing, state work. We're going to hold, people challenging this because these are, people who are doing the best they can, to a higher standard when we're trying to challenge that. But again, AGT versus Osseo, great decision yesterday. All right, and I didn't change. I've given a presentation like this before, and I didn't change the title, but it's Texas v. Kennedy now, because Becerra was the old one. All right, so Texas v. Kennedy was a suit by Texas and 16 states that really delved into these new, again, we're talking about those regulations, under the previous administration put out new 504 regulations. Within the preamble, and by preamble, just again, so we're all on the same page, that's kind of like the introductory paragraphs. They aren't the actual regulations, but they're kind of like the, whereas clauses, and because of, it's kind of like, again, the introduction. They included gender dysphoria as a category and discussed that kind of as alluding to the fact that that was a covered by Section 504. So 16 states and Texas sued. Now that lawsuit started prior to the new administration coming in, and that's again why it is now Texas v. Kennedy. There was an immense amount of pushback, and this was back in March and April, about the fact that there was a great concern, because at the end of every lawsuit, and I don't listen, I can't imagine people read lawsuits for fun, but when you do a lawsuit, you kind of have to use facts. You give the court the, parties, and then the law, and then the facts, and then, you talk about what your different counts mean, and what you're going to prove. But at the very end of it, you put and here's how I want you to fix, Mr. Judge or Miss Judge, what is going wrong. And one of the, I forget if it was 4 or 5 or 6, whereas clauses where they want, how the court to rule, they wanted it to rule that section 504 was unconstitutional. That would have basically have created a situation where we would all lose potential, and we'd lose 504. I mean, it's just, there is no question. And it was not a precursor, or a caution clause. It was just, find 504, rule 504 unconstitutional. It was literally one sentence. What happened as a result of that is there was obviously a massive amount of concern, a lot of pushbacks. And, I did go back and I watched the videos of the different AGs and kind of how they responded to it. Some AGs claimed that wasn't what the lawsuit said, was what the lawsuit said. Some said that wasn't the intent of the lawsuit, and some said we're looking to remove that. They did an issue, I think it was like April 11th, they asked the court to what's known as stay the proceedings. That means, hey, can you put a pause on this? Put a pin in it. We don't want to move forward right now. And hey, FYI, we definitely do not want to, we're not seeking to have this ruled unconstitutional. We really don't want to do that. The court said, fine, we'll wait for the new administration to kind of respond. And I think gave them to April to respond. I think that happened in February. April rolled around and they had to give their first status update. And, effectively the states didn't really give a status update because the Kennedy's administration gave their status update kind of the same day it was due, so they didn't have a chance to review it. But the response by the Kennedy administration basically said, hey, that's in the preamble. That doesn't have any force and effect. And these regulations under Loper don't really have the force and effect. So that's our status update. We don't know what the response of the AGs are going to be to that. But basically, he said, it really doesn't count. It doesn't have any force and effect, but didn't look to, at this juncture, remove it. And I think that may be what the states are looking for. There is another status update in July. It's either the 12th or 21st. I don't know which one it is off the top of my head. But I think that will give us much more clarity in terms of what this fight is going to be. Because the difficulty is even though all the states have said, we don't want to rule Section 504 unconstitutional, that does not preclude the court, if this case proceeds, from ruling that way. That is entirely still a possibility. That's kind of one of those things of, as lawyers, we always talk about is whenever you take a case to court, you basically lose your control. You are now putting it before an ultimate decision maker who is not you, it is not the other side, to make the decisions. And although, again, the state AGs are saying that's not what we're looking for, it is not a case, and that does not preclude a judge from actually saying, no, that is a situation. In fact, it is unconstitutional, and here's the reasons why I think it is. So right now, it's not moving forward. I think we're going to see how Kennedy's response lands with the states, of whether or not that's sufficient for them, or they're going to be seeking other remedies in July. But that's something where, as much as I would love to tell you, hey, we're good, don't worry, where I was a little bit more once I saw the states. And although I'm not at DEFCON 10, that is something still we definitely need to be mindful of and watching and, pursuing as much advocacy. And, there are a lot of different groups right now, LDA included, but other groups as well that are, pushing back against those states who brought those lawsuits to not move forward with the lawsuit. That is something where, again, people reaching out to their AGs, their state reps, basically anybody within the government that you can, and kind of pushing those balls forward. Okay, Carter versus the US. So this was filed by Families and COPA, and it's one of the challenges to DOE's OCR dismantling. And I talked a little bit about this in a previous presentation, but when the DOE executive order came down to start dismantling, and that's what it's called for, dismantling the Department of Education. One of the first things that was done was going and cutting a tremendous amount of staff of the Office of Civil Rights. And what the Office of Civil Rights major function in doing is investigating complaints of discrimination. The vast majority of those complaints are parents with kids with disabilities who are alleging discrimination, mainly within the school-based setting. The avenues of complaint processes that are given to families with disabilities, kind of fall into, several different areas. One is mediation. And also, just so we're on the same page, every state also has some supplemental ones within, the due process realm. For example, we have hearing officer settlement conferences in the state of Pennsylvania. So there's more subtests here, but I'm going to give you kind of the big overview. Really mediation, where you do not need an attorney to go to it. Parents can, pursue a mediation. It is done differently in every state. Some states have different requirements for the mediation. I've participated in mediations in, I think 4 or 5 different states. It ranges anywhere from a trained mediator who specializes in special education. They only do special education mediation, to a lawyer who may not have any training in special education, might have a little bit of training, to a administrative law judge who actually comes in and does the mediation. And generally their training on special education is a 1-day training, because administrative law judges in most states hear a variety of different laws and govern it. So then you also have the due process realm. I'm just going to be perfectly candid, pursuing, and the stats, really do tell us, pursuing a due process claim without an attorney, generally for pro se parents, has not been successful in recent years. They were more successful kind of, back, I would say, in the early 90s, mid 90s, but really have become much less successful. They become very technical. So again, the due process realm. One of the other avenues that parents was free to parents, and they did not have to hire an attorney, where they could actually have, and OCR has trained attorneys, trained evaluators who would evaluate and could even, order remedies for families, was this OCR complaint. So that was, and also OCR would deal with it on a more systemic issue. So it would not necessarily just be about, one child, but they would really look at that system and say, is there something systematically here going on? That this was, again, filed by Families and COPA, really talking about the fact that when OCR the staff was cut, it has effectively, allegedly, you know, put a pause on all investigations, and none of those are really moving forward. And as a result, they're being denied one of the legal rights in terms of that process. So that is a court case that we definitely want to be mindful of, watching and seeing where that goes. Um, there are this is kind of the same lawsuit, but you're going to hear it referred into 2 separate ways: state of New York versus McMahon, and the Somerville Public Schools versus Trump. And these are, again, these are lawsuits that were actually filed with several states as well, filed to stop the dismantling of the Department of Education. On May 22nd, 2025, there was a preliminary injunction ordered to return the DOE to status quo, and reinstate staff. And that's prior. When I say status quo, that means return it to once it was and how it functioned prior to January 20th, 2025. So how the DOE functioned needs to occur. That is where that currently stands. So what is supposed to be happening out of that lawsuit is weekly updates to the courts about the progress that returning of the DOE to its previous status, what's occurring along those lines. From my information that I have, gotten from people who work at OCR, who were cut from the first ones, they have not been given a return to work date. There isn't anything fundamentally, since this order has happened, that I'm aware of. And if somebody here has information that I am not, please share it. But there really has not been, in terms of movement towards that reinstatement of the OCR to, again, what is required by the preliminary injunction, which is the status quo of those prior functioning of the DOE. So here's where we stand kind of right now. There are and this is kind of we are going to have to work to evolve through it. There are a couple things. Again, the legal foundation of disability rights is changing, and it is not going it is not what it we were all very comfortable with what we knew. I mean, as a practitioner, I've been doing this 25 years, I relied on those federal regulations as like the force and effect. Now I'm in a situation where if the hearing off, and we haven't had this, but it is very much going to happen that school districts are eventually going to start taking the position that although a regulation requires them to do something, that was not the intent of Congress. That is going to be something that I think is going to be starting on a much it's kind of like in skirmishes, right? You start taking holes. And again, I don't know where they're gonna start the kind of poking where the weaknesses are. But it's obvious one of the things that school districts have struggled with, and this isn't a criticism. IDA is an unfunded mandate, but there's a lot of regulations and there's a lot of rules around those regulations, and the I think you're going to see a lot of the school districts saying that's not what Congress intended. And the difficulty we have is where we could always, as the advocates and the parents and the attorneys on their side, say, that's what the law says. That is what the law says. That is no longer the case in terms of those federal regulations. Now, there could be case law that has interpreted that way, but this is going to be something where, unfortunately, parents are going to have to push back more than previous, because it is entirely possible a school district lawyer may recommend, and where it says, reevaluations are required, yearly or set by state law, or I think it's every 3 years. They could say, well, that's not what Congress intended. Congress really intended as we saw fit. Or when the child's status changed. So we're not going to be doing full reevaluations. Instead, we're going to be doing review of records every 3 years. And if something pops up during that, then we will go to conduct a full reevaluation, because our assessments of reviewing the written records is enough information for a kid unless we believe that that status has changed. So again, I would not be surprised that that's going to happen. There's going to be at some level, and again, to what extent is they're going to overtake it in terms of, or look to take it on whenever they do regulatory rollbacks or reshaping it, that can absolutely happen under this new administration. To what extent they've already rolled back the Title IX regulations, and this was not via the administration, but via court, to the old Title IX regulations. So we're operating under the 2020 Title IX regulations. What they will do with 504, they did not look to roll those back at this juncture. Whether or not they look to roll those back is going to be seen. And then what they're going to do, although again, there's been no murmur of it at this point in time, but they could seek to redo the federal regulations of IDEA. Now, as I always say, live by the sword, die by the sword. As scary as that might be for us, remember, the courts have also said that that no longer interprets the law. So the reality of the situation is, while it is scary in terms of that new court decision, that there is no interpretation or the deference to which that interpretation for regulatory factors exists, the positive is if there is new regulations out there that, as parents and advocates, we do not think reflect of what the law's intent was, we have that avenue open to us, where with the regulations, it did not. The difficulty, and again, to a certain extent, I look at this as both a positive and negative, because, one of the things that is really difficult for everybody who works in this field is a ping ponging effect, right? If we every 4 years or every 8 years had to say, okay, so it's all been the same law the entire time, but suddenly now it has a whole new interpretation and that's now the new law, that puts it into a lot of flux, and that's not a positive for kids with disabilities. It's not a positive for the people who have to meet those regulations for the school district side. It's not a positive for the attorneys in the courts, because again, we go through this whole process of a 10-year court battle, and now you're in a situation where the law has changed on that. So again, but to give comfort is, if there are new regulations that are, again, things that as either side does not like, they no longer have the force and effect. One of the things too is what you can do at this juncture is go through advocacy, awareness, action, and litigation. I hate to say it, I as much as I am a lawyer, I think most lawyers are conflict avoidant. We try to work things out. We recognize that we send it up before a hearing officer, and or an appeals panel, and or a federal district court judge, and or a circuit, and now, the Supreme Court. We run a risk, right? We run a risk of creating law that we don't want. We run a risk of getting decisions that are outside our control that no party wanted. Um, but that's something that I think you're seeing a lot more of, more people going right to litigation. One of the things that absolutely does need to happen is contacting your representatives, both state and local. The viewpoint of this current administration is to return more things to the local level, especially when it comes to funding. And that's going to be really important, because then you're dealing with a situation where funding is going to be decided, and the allocation of funding is going to be decided through your state reps and state Congress and your state governor's office, and that can have a direct impact on you. That localized level of the translation of money to those areas is going to have a significant involvement in terms of how those funds are given and how those resources are disseminated. So again, you being involved with contacting them is going to be important, because unfortunately, sometimes poor decisions are made not for lack of bad intent, but because of lack of knowledge and understanding the implication of it. A lot of times when I talk to people, they don't even really understand what the Department of Education really does. There's a belief, to a large extent, that it controls curriculum. That's controlled by your state. So again, bringing awareness, action, and litigation is also vital. And Monica, that kind of concluded where I was. I wanted to leave enough time for questions, because we had a lot of them last time. I don't know if we have as many this time, but I'm happy to take any questions.
Okay, well, first I have a comment. So I just wanted to share that one of our participants, Harold Jordan, who's with the ACLU of PA, he noted that the federal government did file an emergency appeal to the Supreme Court last Friday, and I believe that was in reference to the reassembly of the Department of Education. So I don't know if that was something you wanted to comment on.
Uh,
Go
I'm
ahead.
glad they shared that. I suspected it was coming. I mean, because that's what the kind of been the process. I had not found anything when I was prepping the presentation out that it had been done. So thank you for sharing that. That was actually important. We'll have to wait to see what it is. It seems, again, reading tea leaves is reading tea leaves. But what seems to be happening is sometimes the temporary restraining orders, the preliminary injunctions, are put on hold, and they're not required to go through with it until that court has been able to have a chance to look at it, staff it, and brief it. So again, that's kind of been the general what's been happening, but whether or not it'll happen in this case, I don't know.
Okay. All right. So here's a question for you.
Sure.
This is Kathleen Loftus, who is the past president of LDA of Illinois. She currently teaches special ed for administrators. She wants to know if you can possibly provide an example of how the AGT versus OSSEO case could be interpreted by schools. And then also in the Texas versus Kennedy, why is 504 being considered unconstitutional by some?
So in term, okay, so let's start off with the AGT. So how it'll be interpreted by school districts, I'm not a school district attorney. I talk to a lot of them, but just kind of going along their rationale. it really is going to, first of all, depend on the jurisdiction, right? So for like the practitioners in Pennsylvania, the school district attorneys are going to be like, we already knew that. Like we've been operating under delivered in different standard this entire time. This isn't going to fundamentally change anything we do. One thing to remember is we're not talking about compensatory education. We're not talking about the right to an independent. What we are fundamentally talking about is this damages, which are, you have been harmed and it's getting compensation in terms of money for those damages. A lot of this and a lot of these court cases are decided more along the lines of equitable remedy. And what an equitable remedy is it's an in-kind remedy. So for example, if you did not receive, an hour a week of speech and language therapy for 10 weeks, you're entitled to 10 hours of compensatory education. This goes beyond that. That says that's not enough. Those 10 hours of compensatory education don't make me whole. I have been damaged. And then you have to establish, and again, I'm just utilizing the damage of the speech and language. So now let's say I am able to get a report from an expert that says, because I did not receive those 10 hours of speech and language therapy, I will never be able to fully articulate my R's, and so, therefore that impact of not intact, being able to articulate my R's is going to impact my wage loss and how much I can earn over a course of lifetime, because I will not, I won't be able to have jobs that, require public speaking or, whatever, again, the damage is going to be. The standard by which you've always had to prove the comp ed and the lack of services has always been a different standard. This is for when you're talking about that level of damage. And what it has to be is that the district was aware of a problem and was deliberately indifferent to it. And I'll give you some examples, I think, that because maybe that might be helpful. When we're talking, again, so we're talking damages, we're not talking comp ed. So we're talking about kids who have suffered things. So usually when we see a damage case, and the cases I've been involved with and handled are situations where kids have been, for example, a sexual assault that has occurred at the district by a student on student, occurs on a bus. The district said, listen, hey, we could not have possibly seen this coming, that this student would have acted inappropriately with another student on the bus. And going through the court records or the school district records, we were able to find that there were times that this child acted inappropriately with other students. So therefore, we were able to say, we were able to get past the standard because, hey, you knew this child had a chance to act inappropriately with other students, and you put him in a bus where there was not someone who was supervising him, and as a result our client got hurt, and then we would move on to the damage situation. So that's, do I think this is fundamentally going to, and again, I don't want to, how should I say it? I don't want to make it not be a positive, because I think it is a positive. I think it was a positive on a lot of levels. In terms of the impact, direct impact of how this is going to be seen in terms of how courts operate, I don't, I don't think it's going to have that much of a significant impact on it. Because again, for the most part, 99% of these cases are decided on the fact that comp ed is the appropriate remedy, and that, in terms of damages, I have not, perfectly candidly, I have not looked to see what, I know what the basis for the allegations of the alleged damages are in terms of the lack of, this was a child who wasn't able to access the same level of amount of education as other students. I think it got hung up on this court case on what standard to be used. So there hasn't been the full discussion in terms of what that damages actually are and how the court's going to be viewing those damages, or whether or not the court's going to find that there, this was appropriately remedied through the compensatory education. I also don't know in terms of, again, in looking at, because I read the Supreme Court decision, was how much too there might be other arguments hanging out there, like, because you have to somewhat go through a process before you can bring a court case. You have to go through what's known as exhaust your administrative remedies. Not sure to what extent AJT has exhausted their administrative remedies. So where this case goes, I don't know specifically. In terms of what impact this has in terms of actual day-to-day functioning in district, very little. I think, though, in terms of overall the feelings of court not looking to heighten the standards for people with disabilities, great news. The fact that in terms of for Pennsylvania and for states that had deliberate indifference, great news. And for because it gave us like a sigh of relief. And then for just circuits that had the bad faith or gross misjudgment, I think it allow attorneys there to look at court cases to determine whether or not they could bring now a case that they could pursue for damages, because although the fact pattern, an example for mine, is the same, the standard by which we had to prove it was different, and that may not have had the same result in Pennsylvania as it would have had in a situation of bad faith or gross misjudgment.
Okay, before we jump over to the 504 part of that question, I'm
Yes.
going to jump down to another IDEA related question. And that question was, is there any court decision that could water down the implications of Andrew F?
Are there any court decisions that there is, as right now, there is no pending Supreme Court cases that are looking to reanalyze Andrew F. So now, that being said, I think that case, because it's, a Supreme Court decision, we're pretty solid on. At the same token, whether or not there's always a chipping away, and there's always, listen, we lived under Chevron, right? When I talked about that Chevron case, we lived under like this, I know what, these regulations have, and you get a new makeup of a Supreme Court and there's a different decision. Of my totem poles of worries in education right now, Andrew F is not on my my concern. Like, that's not on the radar screen of concerns, but it is something to be mindful of. I think right now, where we are seeing in terms of the direct impact on education, is really going to be coming through funding in terms of the DOE and how funds are disseminated, and whether or not there are the OCR complaints, I think, is having a strong impact on a lot of people in terms of, I think I heard some stat, it was like just in like the Philadelphia area, like it was 17,000 complaints that had not been processed at the time that the OCR was, the staff was cut. And then on top of it is just where you have, and every jurisdiction has them, that attorney who wants to push the ball forward. And if you have a school district attorney who, and I can tell you in a couple states I know who those would be, who really want to challenge this new idea that these federal regulations don't have the same force and effect. I can see some court cases popping up there, and that's going to take a long time to weed its way through the system.
Okay, so the 504, the first one, there's a couple questions here. The first one, going back to the Kathleen's question, she wanted to know, why is 504 being considered unconstitutional by some?
So I'm going to have to tell you, I did read the complaint. I read it a long time ago when I gave a presentation on this. My recollection, it was based upon the spending clause situation, which is this complicated idea that it depends upon receipt of money. So that is my recollection. I'm going to be, again, I know what I know, and I don't claim to know what I don't know. I don't remember exactly. That's my best recollection on that situation. But it wasn't anything to do with like, it was a very technically legal situation. It wasn't something based upon like an amendment of the Constitution, or it was a violation of free speech or something like that.
Okay. All right, another question here. OCR announced a couple of years ago that 504 regulations would be revised. The opportunity was provided for public comment. However, new 504 regs were never rolled out. Is that correct?
No, new 504 regs were rolled out. So yes, that process went through the process. New 504 regs rolled out. That's actually what inspired the Texas v. Kennedy court case, was because now in the new preamble, it indicated gender dysphoria, and the 17 states filed. Again, those were rolled out. New Title IX, and again, there might have been other ones, but I only focus on the ones in the education. New Title IX regs came out under the old administration, and new 504 regs came out under the new administration. Title IX's regulations were challenged, and as a result of that, it was vacated. And so it's as if those new regulations never existed, and we are back to the 2020 regulations. Whether or not new regulations for Title IX come out, I have no idea. In terms of 504, right now, those have only been challenged during this court case. The administration, and again, I think we're going to get a little more clarity in July, what they plan to do with those regulations haven't been told, because again, it's only in the preamble, and there are a lot of good things in the new regulations, but again, whether or not they look to return them to, I'd love to say 2020 regulations. Those regulations are so old. I think they're from the 70s. I think they are old regulations. So whether or not they return them to the old regulations, or keep the new regulations, or they could choose a third path, which is bring them back and start them over and create their own. But again, if we get regulations that are not in line with something that we think is right in terms of what the law was intended for, then those have a better chance of being challenged now than it did before. But again, you live by the sword, die by the sword. That will also happen when you get regulations that you really, really like too. I mean, you may love that new regulation. It could still be held by the courts to not have that same force and effect, and could be said, that's not what Congress means. I mean, to a certain extent, and listen, I'm a lawyer. I love the law. This puts uh, it is now making judges, and this is what I just don't fundamentally like about it. It's now making judges who are now decision makers in all these different realms about what a Congress who's not even currently in existence meant by those regulations. So you know, it makes it very hard. What is supposed to happen, and I think the goal of it is for Congress, when they're writing and drafting and passing these laws, to put more meat on the bones, to really be very clear and intentional with what these different things mean. However, that hasn't happened historically. Whether or not it starts to happen, I don't know. But these federal regulations now honestly put a lot more emphasis and weight on courts to make these decisions. And there is also just a real question, and I think this will be decided by the Supreme Court sooner rather than later. But, usually when you have a court decision, for example, a a court decides to issue a temporary restraining order against a school district going forward with something in Texas, didn't really have an impact with us on the Third Circuit. That was very localized. It is People are now bringing these cases in this much more expansive way, where courts who are not part of our circuit, like for example, it was like in Kentucky or Kansas, it was one of the K states, Kentucky, Kansas. I don't remember. But that Title IX case came out of it, issued the entire it issued it for the entire United States. They did it through the fact that there were stakeholders who were part of that were in presence in every state. Now they did limit it at one point in time where you had to actually sign up, but that was an evolving list. So I'll be blunt. I'm a school board member of my own district. We had like half of our buildings who were technically under that injunction, and half of our buildings weren't, and then we were deciding what we were going to do. But that's kind of the practical impact of that, is that you have, in a single school district itself, we had one buildings who were like, do we follow the 2024 regs because technically there's no injunction against us doing it, or do we stick with the 2020 regs? Do we all go 2020? Do we all go 2024? And it put the administrators and everybody kind of into this difficulty, because there was a lot of changes under Title IX, in terms of the process of the investigation process, how that would evolve, the standards by which, cases would be judged by. And we're going to, unfortunately, I think we are entering a period of a lot more uncertainty, in not clarity and differences, than we are more towards stability and consistency, because that has been my experience in terms of how these cases and the impact of it has.
Okay. There's another legal type question. Let's see. Trying to find it. Is there a statute of limitations with regard to life damages?
So I'm going to answer the question the way I think I understand it. So if I don't understand it correctly, if whoever asked that can clarify. So when we look at damages, it has to be what that damage is. There are some damages that are going to be seen at, and again, it's not just what a person feels, it's what an expert's willing to testify to. So for example, and I'll do an easy one. I was involved in a case where a student who was residentially placed was brought off property by one of the staff members to their home property to go horseback riding. That student was thrown from the horse and paralyzed from the waist down. So in terms of a lifelong damage, that is something that we had expert reports that talked about the lifetime impact, and that had different impacts over the course of lifetime. So, while he was young and was very ambulatory, or, had a lot of physical ability, what he would need as an elderly person would be, he might have greater need at that point because again of the impact of the paralysis. So yes, you can get damages for a lifetime, but it also has to be upon a expert who has evaluated and determined that. So, I'm going back to the example I had about the Arctic issue. The likelihood you're going to get an Arctic, being able to an expert report for a lifelong damage, you don't know. As plaintiffs in cases, you are looking for the largest amount of damage, asked as possible because again, you're looking to make sure that that person has the resources necessary for all aspects that could impact, but that is very dependent upon what occurred and what experts are willing to testify to the lifelong damage. In terms of the sexual assault case, that was more seen as the level of therapy and costs of different supports and services that would need someone to be able to recover from that, and be able to have a life where that was not a lifelong impact. And that, again, goes into the factors numbers. So yes, you can have a damage that is seen as a lifelong and has differing costs along the way. You can also be damaged in a very significant way, and it may take a significant amount of resources to get you back to where you would be prior to the damage. But it wouldn't be necessarily lifelong. And that would be the goal of that damage uh, request, is to ensure that this is not a permanent lifelong damage. And if I didn't answer that correctly, please paraphrase and I'm happy to re-go over it.
Okay. There's a couple questions about information being taken down from the Department of Ed website and things like the What Works Clearinghouse. There's a worry that some things would be deleted. Do you have any thoughts on that? I can also share some things, but I'll
Yeah,
let you.
I mean, that is a concern. Whether or not that information ever gets put back up, I don't know. It really is it has a significant impact for advocates and attorneys and parents, because there is a lot of things like the Dear Colleague letters, IDELR decisions, What Works Clearinghouse, that was provided a lot of information. Because listen, as an attorney who represents parents, and as a parent myself, you don't get that information. Like if you say to me, I'm giving the Read 180 program, right? I don't know what the Read 180 program was. I didn't know if it was right for my kid. I didn't know if it was right for my clients. I was able to go to like What Works Clearinghouse and look at it, and they would make it into very user-friendly terms, which is, this is a reading program that addresses this. This is what the research has told that it works with. And I was able to be a much better advocate for my clients, for my own kids, because I would say, well, but his issues are here. This doesn't really impact, or this doesn't show that this is actually effective for these reasons. And it put me onto somewhat a playing ground where I could have conversations instead of, in the Fourth Circuit, there really is a push towards not questioning the judgments by the educators. In a lot of respects, it is hard to, because you're not an educator yourself. So as much as you can download and database, and I don't listen, again, as I said from the very start, I am not the technology person in my firm. That being said, my understanding is that there are like called like the Wayback Machine, that you can actually see websites as they were published on previous dates. The process by which you do that, I'm not the target audience to ask that because I don't know it, but my understanding is there are ways to see websites and how they existed prior to dates and time. I don't think it's as expansive as we want, but at least there might be some ability to go back and get that. I have not tested this, but I will plan probably to test it, is if you but the accuracy is always questionable. You can try to use Chat GPT or AI to say, is there a dear colleague letter, for example? Like there's was a really great dear colleague letter about who retains the right to ask for an independent in terms of, does the district get to tell you who to use, or can you pick the person you want? Because again, that isn't clear in the federal regulations. And this was asking the Department of Ed, hey, Department of Ed, when you said about an independent, like, does the district get to pick that person, or does the parent get to pick that person? And there's a dear colleague letter about that. Whether or not that's still on the website, I don't know, but I know that exists. And getting to Chat GPT to see if they can find it, or an AI support system to help you get back to those things. But I will just say this. I do caution you when using Chat GPT for legal purposes. A lot of attorneys have lobbed onto that, and Chat GPT, they will give you it. They will give you the court case. It'll give you a full legal site. It'll give you a case breakdown, and you think you have cracked the code. Um, and it's just wrong. I mean, it's just bluntly wrong. If you go back and read the case, it doesn't say anything that Chat GPT claims it said. There are a lot of attorneys who've been utilizing Chat GPT who've been really smacked by courts for that. And bluntly too, even research, and I'm sure, Monica, you're aware in the field, like, Chat GPT will and AI will just create sites of studies to prove their case that do not exist. So you do need to, if you're utilizing AI, especially if you're trying to get information because you cannot find it on the Department of Ed's website, you do need to be mindful that you need to be cross-checking that with other sources, because the accuracy of which may not be 100%.
Yeah. Yeah, and I would also say that there are, in addition to using the Wayback Machine individually, there are different groups out there and coalitions that are trying to put together, download a lot of documents and put together some databases for that. So maybe one of the things we can work on at LDA is trying to see where that work is, and maybe if we can find some good sources, putting some links on our website to that. There is really just one other question, I believe. There were a couple questions about, where we can find those Section 504. I know at the very end of the Biden administration, some of the coalitions that LDA is a part of, we had information that things weren't quite finalized. And so maybe some of that stuff never did make it out to the public, but we can look into that. And then there's another question that's interesting. It's about some of you may have heard that IDA, the International Dyslexia Association, is revisiting its definition of dyslexia. And one of the questions was, how will that impact students who have been determined eligible under SLD and having dyslexia? That's coming from a diagnostician in Texas. I don't know if you want to comment on that, Heidi, or
So in terms of the IDE, there's going to be two ones. In terms of the IDEA, it doesn't have an impact. And the reason for that is dyslexia isn't even identified in terms of the IDEA. There are, in terms of a specific learning disability, there are different areas in reading, like reading fluency, reading comprehension, decoding. I think there's different areas where it's specified what a reading disability is. That's always been kind of the weird conundrum in the state of Pennsylvania. Was for some reason districts felt you could not put the word dyslexia into an IEP or evaluation board. There's no prohibition against that. But in terms of the impact of reanalyzing how dyslexia is identified, that is not going to change unless we have new regulations for the IDEA. There's been nothing in the works in terms of any time of, because it is an undertaking to redo the regulations. Plus, those are specified in terms of specific learning disabilities within, and again, dyslexia is not mentioned either in the ID itself or the regulations. There is reading disabilities, but there's nothing that prohibits that. Under section 504, again, if it is a student with a disability that impacts a major life function, it's not going to really impact that as well. So right now, we are not in a situation where that would be something that I would be concerned about fundamentally altering it, whether or not under new reauthorizations or new regulations, or when the IDEA, again, goes through reauthorization, that is going to be a different, that could be a different ball of wax. I think there is a lot of talk in the community. So if that is a concern of yours, definitely giving feedback when it is thought about the new regulations and involvement in that process would be important.
Okay, we are at time, a little bit above overtime. So thank you everyone for today. Thank you so much, Heidi, for a very informative presentation. And again, if you are not a member of LDA, please consider becoming one. This has been recorded and we will send out the PowerPoint and the recording to members. And I would encourage anyone who's not a member to consider becoming one. Thank you.
Great. Thank you, everybody.